Under Title 9, Crimes Against Personal Liberty and Security, the first among this is, under Article 267, we have kidnapping and serious illegal detention. Kidnapping and serious illegal detention is committed when the following elements are present. First, that the offender is a private individual. Second, that he kidnaps or detains another or in any other manner deprive him of his liberty. Third, that the said kidnapping or detention is illegal. And lastly, that the said kidnapping or detention is attended by any of the following circumstances. First, when the kidnapping or detention shall have lasted for more than 3 days, or if it is committed by simulating public authority, or if any serious physical injuries shall have been inflicted upon the person kidnapped or detained or threats to kill him had been made, or if the person kidnapped or detained is a female, a public officer, or a minor. These are the elements of kidnapping and serious illegal detention. The offender in kidnapping and serious illegal detention is a private individual. If the offender is a public officer acting color of authority, it is arbitrary detention. But if he is a public officer acting in private capacity, still, it is kidnapping and serious illegal detention. The circumstances mentioned in the third element are the circumstances that will make the illegal detention serious in nature. If you remove all these circumstances, the crime committed would only be slight illegal detention under Article 268. So if the kidnapping shall have lasted for more than 3 days, serious. If it is committed by simulating public authority, serious illegal detention. If any serious physical injuries had been inflicted, threats to kill made, serious illegal detention. The moment the victim is a female, a woman, a public officer, or a minor, a child, it is always and always serious illegal detention. The following circumstances will qualify the penalty to death. When the kidnapping or detention is for the purpose of extorting ransom from the victim or any other person. We have kidnapping and serious illegal detention for ransom. Then we have when the victim of the kidnapping or detention, when the victim is killed or dies as a consequence of the kidnapping or detention, or is raped, or is subjected to torture or other dehumanizing acts, the maximum penalty, that is death, shall be the one imposed. That is under the last paragraph of Article 267. So the moment the person kidnapped or detained is killed, in the course of the said kidnapping, we have the special complex crime of kidnapping and serious illegal detention with homicide. If the said victim is raped, we have kidnapping and serious illegal detention with rape. In case of kidnapping and serious illegal detention with homicide, kidnapping and serious illegal detention with rape, it is necessary that the victim of the kidnapping or the detention must be the one who has been killed or who has been raped. If it is another person who has been killed or who has been raped, it will constitute a separate and distinct charge. It is no longer in the special complex crime of kidnapping and serious illegal detention with homicide or with rape. The brother A brought his younger brother B in the gym. He would always go to the gym every weekend. And so brother A brought his brother B to the gym. Thereafter, brother A left on board the car. Few minutes, he has not yet reached the office. He received a text message. In the text message, there was a statement saying that we have your brother, and your brother would only be released if you will give 10 million pesos. Brother A could not believe it. He knew he just brought his brother B to the gym for his physical fitness. And so what he did, he called the gym. And there they said that there was no B. So B had been kidnapped. And he informed the authorities. Again, there was a call from the kidnappers to A and asking for the 10 million, warning him not to inform the authorities. And they set the place wherein the money will be given, the exchange of the money, and the said kidnapped victim. On the said place, A arrived. However, the kidnappers were able to determine that there were police officers nearby. The kidnappers left without taking the ransom. And the moment A and the police arrived, they found B already dead. What crime or crimes has been committed by the said kidnappers? What was the criminal intent? To kidnap and detain. For what purpose? To extort ransom. Therefore, the crime committed is kidnapping for ransom. The said victim died or is killed as a consequence of the said kidnapping. Therefore, we have the special complex crime of kidnapping for ransom with homicide. What if in the said problem, when A went to the designated place, wherein there will be the exchange of the ransom and his brother, the police officers went there together with A, and then thereafter, with the use of a microphone, they announced to the kidnappers that they were there. They informed the kidnappers that they were there. And so the kidnappers fired at the police officers. There was this exchange of gunfires, and in the course thereof, the kidnappers were able to hit one of the police officers trying to rescue. Later on, because of the enforcement that arrived, the kidnappers were arrested. And inside the hideout, they found B dead. What crime or crimes had been committed should be filed against the said kidnappers. First, insofar as the kidnapped victim B is concerned, the crime committed is kidnapping for ransom with homicide. Again, the intention was to extort ransom, and the victim was killed as a consequence of the said kidnapping or detention, kidnapping for ransom with homicide. But the police officer died. Is it absorbed in the kidnapping for ransom with homicide? It is not, because the police officer is not a kidnapped victim. Therefore, there is another charge, another crime to be filed against the kidnapper, and that is qualified direct assault with homicide. The police officer is an agent of person in authority. He was in the performance of his function, trying to rescue a victim at the time that he was killed. And the kidnappers made use of weapon. Therefore, two cases should be filed against the said kidnapper. One is kidnapping for ransom with homicide, a special complex crime, and a separate and distinct charge for qualified direct assault with homicide for the death of the police officer. The mother was doing her laundry. While the mother was doing her laundry, her 10-year-old girl was there playing with the other girls. She could see her girl within her watch. While the girl was playing, here comes a man by the name of X. The man went to the girl and offered the girl candies. The girl was so happy. Minutes later, the man went back to the girl and gave the girl money. And the man told the girl, "Would you come with me?" And the girl said yes. And so the man held the girl, 10-year-old girl, by the hand, and together they went to the house of the man. Meanwhile, the mother was finished with the laundry. She looked at her daughter. The daughter was gone. She tried to look everywhere. She could not find the daughter. She had the same be blottered. She could not locate the daughter. They slept. The following morning, there was a knock on the door. And the moment the mother opened the door, there was her 10-year-old daughter. There was blood on the dress of the said daughter. And she asked the daughter what happened. And the daughter narrated to her what X did to the said daughter. According to the daughter, the said man had inserted his penis inside her genitalia 2 times. And so because of this, a case of kidnapping and serious illegal detention with rape had been filed against the said man. If you were the judge, would you convict the man as charged? If you were the judge, you should not convict the man as charged. Of what crime would you convict the man? You have to convict the man of 2 counts of statutory rape and not a special complex crime of kidnapping and serious illegal detention with rape. Why 2 counts of statutory rape? Why not kidnapping and serious illegal detention with rape? Because based on the facts, there was no intent to detain the girl. To bring about kidnapping and serious illegal detention, it is necessary that the intent of the offender is to detain the victim. Here, obviously, the intent of the man was to have carnal knowledge of the girl. Since there were 2 acts of carnal knowledge, therefore, 2 counts of statutory rape, the girl being under 12 years of age. It is not kidnapping and serious illegal detention with rape. In case of kidnapping and serious illegal detention with homicide, kidnapping and serious illegal detention with rape, since it is a special complex crime, regardless of the number of times the victim had been raped, it will only be one special complex crime. I said earlier that if none of the circumstances that will make the illegal detention serious, the crime committed is only slight illegal detention under Article 268. Under Article 268, in case of slight illegal detention, if the said offender voluntarily released the kidnapped victim, the penalty will be extenuated or mitigated. And this voluntary release will be a mitigating circumstance if the release was made under any of the following circumstances. If the release was made within 3 days from the commencement of the detention. If the release was made without the offender having attained his purpose. If the release was made before the institution of criminal proceedings against the said accused. If these circumstances are present, then the voluntary release of the offender of his kidnapped victim would lower the imposable penalty by 1 degree. Note, if the victim of the kidnapping is a female, a public officer, or a child, a minor, it is always kidnapping and serious illegal detention. Therefore, no need for any other circumstances. The mere fact that the victim kidnapped or detained is a female, a public officer, or a minor, it is always kidnapping and serious illegal detention. And if they are the victim, even if they are released a day after, it will not mitigate the criminal liability of the offender, because this mitigating circumstance of voluntary release under Article 268 applies only in case of slight illegal detention, never in serious illegal detention. Under Article 269, the law punishes unlawful arrest. There is unlawful arrest when the offender arrests another for the purpose of delivering him to the proper authorities without any legal ground. This is not authorized by law. The offender in unlawful arrest can be any person. He could be a public officer or employee. He could be a private individual. His purpose is not to detain him. His purpose is to deliver him to the proper authorities, that is, to file a case against this person who has been unlawfully arrested. Under Article 270, kidnapping and failure to return a minor, this is committed by any person who has been entrusted with the custody of the minor, and he deliberately failed to restore the said minor to his parents or guardian. There must be a deliberate intent not to restore the minor to the parents or guardian. Inducing a minor to abandon his home, this is committed when the said minor is living in the house of his parents, guardian, or any person entrusted with his custody. And the said offender induces the minor to leave the said place with the deliberate intent of causing damage to the said minor. There must be deliberate intent to cause damage on the said minor. Mere inducement will suffice. It is not required that the minor would have actually left the house, but Thus, an inducement must be made directly with the intent of causing damage to the said minor. If you will look under Article 171, second paragraph, both Articles 270 and 271, kidnapping and failure to return a minor and inducing a minor to abandon his home, both can be committed even by the parents of the said minor. So even parents who fail to restore the minor to the legal guardian can commit this crime. Only the penalty is lowered. The penalty is only arresto mayor. The man, X was driving his car. While X was